The much-awaited Ayodhya verdict has been delivered today by the bench led by Chief Justice Ranjan Gogoi. We are now with Supreme Court Advocate Mr. J. Sai Deepak, who would help us to understand the nuances and what exactly this judgment, which is 1045 pages long, mean to the several parties in the cases. Sir, can you just briefly first explain that what are the major takeaways from the judgment?
So, I must confess that I have not had the opportunity to read the entire judgment, but from whatever little I have read so far and whatever I have followed so far based on the Supreme Court's pronouncements, one, I think while the fundamental principles of adjudication which were adopted by the Allahabad High Court have been retained, there is a significant departure in certain outcomes and critical outcomes as far as the Supreme Court verdict is concerned. So, for instance, one, as opposed to dividing the land three ways between the Nirmohi Akhada, the Sunni Waqf Board and Ram Lalla, so to speak, the court has decided that the entire land has to go to Ram Lalla Virajman, the deity itself, which has been recognized as a juristic person by the Supreme Court itself once more. And on the basis that the Nirmohi Akhada, its suit is barred by limitation. As far as the Sunni Waqf Board is concerned, it has not proved its case either on the basis of title, possession or adverse possession. So as a consequence of which the entire land, which is known as the Ram Janam Bhoomi, has now gone to the deity itself. That's point number one. Point number two, apart from allocating or rather giving this land back to the trustees or actually directing the formation of a trust for this particular land, the court has directed that a separate piece of land for about 5 acres be allotted for the construction of a masjid, preferably I think on the other side of the Saryu river. So that's point number two. Point number three is that the Supreme Court has categorically said that the ASI report cannot be dismissed as guesswork, and there is legitimate evidence and scientific evidence which is to be considered. The only thing is the ASI report establishes the existence of a non-Islamic structure and therefore a temple under the disputed structure, and also that the disputed structure, which was demolished on the 6th of December 1992, was not built on vacant land, which effectively means that the possession was certainly not peaceful. The only question that the court was asking itself was whether the ASI report also points to the factum of demolition, which the ASI report cannot, because it only focuses on the existence of a structure. It doesn't shed light on history beyond that. Therefore, the court has then considered other aspects, such as who's been in possession, who's been in exclusive possession, so on and so forth. So the court has come to the conclusion that as far as the outer courtyard is concerned, the Hindu side, so to speak, if at all that's the way to call it, has been in continuous possession of it, and they've been using it for prayers. And the Muslim side has failed to prove exclusive possession of the inner courtyard, which has been their case all along. As a consequence of which, there is a continuous proof of, let's say, use for worship by Hindus of both the inner courtyard as well as the outer courtyard, meaning thereby one doesn't need to identify which is the exact place which is treated as the birthplace of Ram. The entire place effectively becomes kshetra, so to speak, which is effectively treated as a place of worship. So that's been the Supreme Court's verdict.
Sir, this whole case from very beginning has been perceived from two angles. One, a civil suit, which concerned to the title of the land. Another was about faith. And there was always this question that how Supreme Court would maintain a harmonious balance between the two. So how do you comment upon this, that how far Supreme Court has been able to do this?
So the important thing about this judgment, as well as the verdict of the 30th of September 2010 of the Allahabad High Court, is that the discussion around legal issues and strictly legal issues have commenced only after the verdicts have been pronounced. And until then, if you look at the tone and tenor of the discussion in public discourse and everywhere else, it's been about politics, it's about sentiments, it's about religion, it's about culture, not about the actual legal principles that apply to it. So I think, fortunately, this judgment reinforces the need to have a saner discussion, particularly on legal issues, as opposed to throwing in inflammatory comments. So I think what the Supreme Court has done is that it has chosen to apply well-settled principles of let's say, adjudication of civil disputes with respect to title deeds to the facts of this case, and has tried to steer clear as much as possible away from a discussion based on religion entirely, and has used religion only to the extent that it adds value to the central claim of who does the land belong to, who has it been in continuous possession of, and who's been using it for the purposes of either prayer or worship, depending on whoever you're talking about. So in fact, the Supreme Court has applied those principles of limitation, has applied those principles of adverse possession, has applied those principles of documentary evidence, coupled with the ASI evidence, to come to the conclusion that these are the reasonable outcomes. So if you look at the progress between the Allahabad High Court and the Supreme Court, the only limited appeal of the Hindu side, so to speak, has been that if the Sunni Waqf Board has failed to prove its title, possession or adverse possession, for what joy was it given 1/3 of the land? And that is what I think the Supreme Court has also agreed with that particular grievance and has endorsed that particular position, that a party that has failed to prove its case cannot be entitled to any part of the disputed land. However, it is to bearing in mind, let's say, the need for social harmony, or so to speak, whatever the court has called it, it has decided to allot 5 acres. So on that particular issue, the court seems to have said that even when deciding civil suits, particularly of this nature, a court must be cognizant of its constitutional duty to preserve harmony and at the same time its obligation to secularism. So that seems to be the approach of the court.
So this is a landmark judgment. So what do you think that this would have a kind of ramification on other similar case? Sabrimala review petition is also like so.
Since I'm a counsel in the Sabrimala review petition, I'd like to reserve my comments on it, except for the fact that the court's finding, there are 2 principal findings which I think have very strong implication for all matters which are related to religion and faith. One is that the deity under Hindu law, as accepted by Indian law, is effectively a juristic person who enjoys rights that can be proprietarial rights, and I would say even fundamental rights, so to speak. That's point number 1. Point number 2 is that when it comes to matters of faith, unless and until there is evidence of a fraud being played upon court on the in the name of faith and on the basis of faith, the court has no other option but to accept it, and that seems to be a settled principle of law, not just in India, elsewhere as well. If you look at the US Supreme Court or even courts elsewhere, whenever it comes to a religious practice, they consult the expert on religion, and unless and until the court has any basis to come to the conclusion that they are being misled, they have no other option but to trust what the expert has said with respect to religion. So that, I think, is very, very important. So I think this will have significant implications for this, but most importantly, this judgment sets out a fantastic template for other contested areas as well, other temples as well, and what they call as other occupied sites as well. So one would have to see how this judgment can now be used to challenge the legitimacy, legality and constitutionality of the Places of Worship Act of 1991, which effectively bars indigenous communities from reclaiming their places of worship and creates an exception under Section 4 only with respect to Ayodhya. So the question that can be asked is, why only Ayodhya, why not other places as well? Because that would be, to say that one place can be contested but the others cannot be, would be a direct violation of Article 14 and Article 25. Equality, requirement of being non-arbitrary, and also the right of religion of a particular community to reclaim its place of worship. So that will be the significant aspect.
Thank you so much, sir, for throwing light on this judgment. It would help our readers to understand this judgment in a better light. Thank you for watching First Post.